Welcome to the short presentation in which Basil Manuel of NAPTOSA and I, Anthea Seresto of the Governing Body Foundation, will tell the truth about the BELA bill and try to put an end to some of the scaremongering that has been on our social media. The BELA has been in development stage for more than 8 years. And an organization such as the GBF and NAPTOSA have commented at every opportunity. We've sent written comments, we've participated in oral hearings, we've presented in Parliament, and as a result of this process, some of the less acceptable amendments have been removed. And we are left now with a few sticking points around which the fear has been stirred up. So we want to deal with what the social media has been saying, and in order to help you understand and not be confused by some of these things. The campaign to vote no focuses only on a few amendments, but there are good things in the bill and things that will be helpful to schools, which will prevent the abuse of power by officials, and others will present the abuse of school funds and will make certain sections of SASA, the South African Schools Act, clearer. So the sooner these amendments are implemented, the better it will be for schools. So we look at the amendments around which these rumors have developed.
Let's talk about compulsory schooling and the whole issue of parent prosecution. Now, of course, there's nothing new here. The truth is that SASA does make a parent liable for a fine or imprisonment if a learner does not attend school. It's not a new story. However, to put it into perspective, it must be the willful, unjustifiable denial of the child's right to go to school. That is a criminal offense. It is not that my child was sick and has stayed absent and now I will be prosecuted.
Yes, and the next one concerns grade R being compulsory. This is true. Some of the logistics of making this possible still need to be sorted out, but it is most definitely a good thing. When grade 12 results are announced each year, people say there should be greater focus on the early years of education to avoid the dropout, to avoid poor performance. So making grade R compulsory will ensure that children have the opportunity to get a good early start to formal education. So compulsory grade R means that children must be in school in the year that they turn 6. So in South Africa, compulsory schooling will be from grade R to grade 9. That is the year in which the children turn 6 until they turn 15 or pass grade 9.
One of the most contentious issues in the bill has been the powers of the governing body and the admissions and language policies. Now, the truth is the bill has been revised, but remember, it's still a bill, it's still pending approval, and it will ensure that school governing bodies maintain the authority over a number of things. It does, however, hold on to the provision that the head of department does retain the authority to instruct a school to offer more than one language. But importantly, the SGB has the right to appeal to the MEC. The SGBs do not have to submit the admission policies to the head of department for pre-approval. Notably, the head of department is not required to approve these two policies. Instead, the SGB must adhere to the criteria outlined in Section 5 of the bill. And that is the important thing. Stay within the framework of the law and you ought not to have any problems.
The next one concerns discipline. And discipline is most certainly a headache in schools. And sometimes schools handle this in an unlawful manner. Serious misconduct must be dealt with according to the relevant provincial regulations. And I just want you to note there are two kinds of suspension, and the one that the BELA bill concerns is the one for precautionary suspension. In other words, suspend the learner before the disciplinary hearing conducted by the school. There is also suspension as a sanction or punishment for the misconduct. So precautionary suspension for serious offenses now comes in two forms. If it's serious misconduct, as in specified either in the regulations or the school code of conduct, a learner must be given a chance to make representation why he or she shouldn't be suspended. But in recent amendments, what is now being called the C list, the National Council of Provinces has said in the case of very serious offenses, the learner will not need to be given a chance to make representation. And these offenses include the criminal offenses, such as assault and murder and rape and sexual offenses, but also drug offenses. And I do believe people would support that. When it is serious misconduct of that nature, then learners do not have to be given an opportunity to make representation. But for the most part, a principal or an SGB can't just send a child home and say, go home. They first need to talk to the learner and find out whether there are any just reasons, because denying a child education, the right to education by suspending, is not acceptable unless proper process is followed.
The whole issue of comprehensive sexuality education seem to appear in many, many videos. The truth of the matter is it has never, ever been in the bill. And we are mixing up more than one issue. But CSE is a toolkit currently. It's not policy. And we need to deal with it in its own space. And I know that it is very, very controversial. But it is not in the bill. There's no provision for it in the bill. And stakeholders that have a serious issue with this need to deal with it in the right place and meaningfully engage. I need to point out that because it is not a policy, it hasn't gone out for public comment. It is simply a toolkit. And we need to attend to that so that those things that make us uncomfortable can get removed.
Now, the question of who determines the curriculum is important. And the rumors have been saying that the government will control the curriculum, and in fact are indicating that the government is going to include more sinister things in the curriculum and in fact become a bit totalitarian about what is done in public schools. Well, the state of at the moment is that the Schools Act, Section 61, already empowers the Minister of Basic Education to prescribe national curriculum statement applicable to public and independent schools. And this has been so forever, since the Schools Act was implemented years ago. This is done through the publication of regulations. And our current curriculum, which everyone knows by the name CAPS, was published in regulations after extensive public comments. If the curriculum is changed, and the minister is empowered to change it, draft regulations containing amendments to subjects from grade R to grade 12 will again have to be published for public comment. The curriculum must be taught as has been published. I don't think people are really afraid of the curriculum CAPS. It is some of the workbooks or the lesson plans to teach the curriculum that has caused concern. And Basil referred to that aspect in the previous slide. So public is always consulted when there is any change to the curriculum, the published compulsory curriculum.
One of the other contentious matters has been the issue of the sale of alcohol. Now, I've never ever suggested that alcohol should be sold during the school day or during school functions, but rather it was so that when a school lets the hall or whatever, during a private function or after school that alcohol could be sold. The outcry has been so much that, of course, this clause has been dropped completely. Now, there are schools that are feeling a little hard done by because this was part of a money-raising venture when they let a school hall. But that will now have to be re-looked at, and that is, of course, within the province of the governing body. But alcohol will no longer be permitted to be sold or utilized on the premises of the school.
A very heated matter is this one of abortion, and that the schools are authorized to mandate it. The Schools Act and the National Education Policy Act empower the minister to make regulations or policy, and that they will then have the effect of law. And there were two school cases where the Constitutional Court instructed the Department of Basic Education to publish policy relating to the handling of pregnant learners. And that policy was called the Policy on the Prevention and Management of Learner Pregnancy in Schools. And the policy, as its title indicates, is aimed at the prevention of learner pregnancy and then how the school must manage should learners be pregnant. The main aim of the policy is to keep learners in school and to ensure the right of education even for pregnant learners. They need to be assisted while they are absent from school with educational material and then enabled to reintegrate into school after the birth of the children. The whole matter of abortions is dealt with in other South African law. For example, the Choice of Termination of Pregnancy Act. So the BELA bill certainly doesn't compel the principal or teachers or other staff members to assist learners to access abortions. The policy aims at helping schools devise school policies that meet constitutional rights for the child's education and also protect learners and enable them to continue their schooling.
Still sticking with the same issue around parental authority. Of course, parental authority cannot be taken away and it cannot be vested in the school over and taking away the rights of parents. And this extended further into all the rumors around homeschooling, that this will strip the parents of the right to control their child's education. Now, the truth is, there are many parents who have opted for homeschooling, and that will continue. That is a right that is enshrined. But there are a few things that we must remember will happen. First of all, the registration of the pupil with the department. The department has a right to know because all children, it is compulsory for children to be at school. And if you are homeschooling, you must register so that we know your child is in fact in a school. You have to indicate the curriculum of choice because nobody can simply just teach anything that they would like. There must be a curriculum. And then, of course, there must be intermittent assessment. And how this will work will be spelled out in regulation. But what is important, that the unregulated nature of homeschooling has changed, not homeschooling in itself. Regulations will ensure that homeschooling children can then also be more easily absorbed into the mainstream if they so wish. If one simply just taught whatever one pleased, and then tomorrow the child needed to go to a formal school, it would be enormously difficult. And so this is why this particular provision is there. But to state, the right has not been removed. So, where are we now with the BELA bill? Now, I'm stressing, and Anthea stressed too, it is still a bill. We have not yet seen this being enacted into law. So the Select Committee of the NCOP, the National Council of Provinces, will now have a re-look at the bill when it is all written up, and by within the next few days, we will see the new version of the bill to see that the language, etc., complies with what the decisions intended it to comply with. Thereafter, it has to go back to the National Assembly, because the National Assembly, remember, agreed to a bill that was slightly different to the one that we now have come to know to be the one that hopefully will see the light of day. After that process, it goes to the president for his agreement and that signature. And once that signature has been appended, it then becomes an act of parliament, a law. Everybody wants to know, will this happen before we have a new government in place? Well, neither Anthea nor I can actually tell you that. There is a hope that it will happen, because there are many positive things, as Anthea said at the beginning, that we would like to see happen. If you have other questions, and our contact details will appear. But here is something that I want to encourage you to do. We want you to read the new BELA. There are many videos that are completely out of line with what is actually there. And let's not buy into the sensationalist and things that are there and the misinformation. Read for yourself, because your knowledge is power. And you will see that an informed citizenry must be and is the foundation of a robust and fair society. From Anthea and I, thank you. We hope this will help you to empower yourself.